You bring a personal injury claim and either the settlement offer is too low or the insurance company thinks you're at fault and won't make an offer to settle your case. What do? Do you have to go to court? The answer is not if you don't want to. The decision to go to court or not is your decision, not the lawyer's. When a case can't be settled, there's usually 4 possible options. You can go to court and begin the litigation process. This is your only option, short of just dropping your case altogether if the insurance company denies your claim outright and makes no offer to settle. You can choose to accept whatever offer has been presented, even if you believe it's too low, because it's 100% your decision. Many clients have no interest in going to court, despite our suggestions that they should. In certain cases, when there has been some offer, but you believe it's too low, we can attempt to either mediate the case or arbitrate the case. Let me briefly describe mediation and arbitration. Mediation is a process by which our client and the insurance company, along with the lawyers, will get together in a conference room with a mediator and try to settle the case. A mediator is usually a retired lawyer or judge who tries to bring the parties closer together on settlement value. A successful mediation ends with an agreement between the parties. The mediator simply helps the parties get there. Mediation is a voluntary process, and many times the insurance company is not willing to mediate the case. Also, there are times when the mediation fails to produce a settlement and you're back at square one and must decide to either accept the offer or go to court. The important points to remember about mediation are A, both parties must consent to going to mediation, and B, the mediator only facilitates the process. Nothing he or she says or does is binding on the client or the insurance company. If either side is not satisfied with the process, they're free to walk away and pursue other options. The other voluntary option is arbitration. Arbitration can be thought of as a less formal, less expensive, and quicker trial. The parties can agree to go outside of the court system, like mediation, and allow a hired judge to decide their case. Arbitration is similar to mediation in the sense that we're staying out of the court system. We have a third-party neutral, being either a retired lawyer or retired judge, who acts as the judge, and he or she will hear the evidence and make a final decision on the case. There are advantages and disadvantages to arbitration over traditional litigation. It's quicker, it's less expensive than preparing and trying a case in court. The disadvantages are you're committing your case to the binding decision of one person as opposed to a jury, and there's no right to an appeal if you believe a mistake was made. The arbitrator's award is final. The important points to remember about arbitration are A, like mediation, both parties must consent to the process. B, the arbitrator's decision is binding on the client and the insurance company. If mediation or arbitration are not options, then a client must either accept an offer that has been made or initiate a lawsuit and seek a trial. Sometimes clients accept offers that we believe are too low because they do not want to go through the whole process of litigation. Litigation is expensive and time-consuming, and in certain cases, it's simply not worth it to the client to endure the process. Other times, it certainly makes sense to fight all the way. An experienced injury lawyer can help you when making such tough decisions.